You're listening to Bloomberg Law with June Grasso from Bloomberg Radio.
I couldn't agree more with President Biden. U.S. Steel should remain American-owned and American-operated.
It was no coincidence that in a campaign blitz on Labor Day, Vice President Kamala Harris, courting union voters in the crucial battleground state of Pennsylvania, where U.S. Steel is headquartered, announced her opposition to Nippon Steel's $14.1 billion takeover of the iconic American company, a deal that the United Steelworkers Union also opposes. The proposed deal has been subject to a review by the Secretive Committee on Foreign Investment in the United States, or CFIUS, and President Biden plans to kill the deal as soon as CFIUS formally recommends it be scrapped, according to Bloomberg sources. Of course, Biden announced his opposition to the deal way back in March without any CFIUS recommendation, an unusual move. Several business groups, including the Chamber of Commerce, sent a letter to Treasury Secretary Janet Yellen today, warning that the administration's national security review of the deal is being unduly influenced by political pressures. Quote, "We feared that the CFIUS process is being used to further political agendas that are outside the committee's purview." And both companies have suggested they could challenge Biden's decision in court. Joining me is Rick Sofield, a partner at Debevoise Plimpton, who was formerly the Justice Department's CFIUS representative. So tell us about CFIUS and how it operates.
CFIUS is the Committee on Foreign Investment in the United States, which is an interagency body made up of representatives from various U.S. federal government agencies. It includes agencies such as the Department of Treasury, the Department of Defense, the Department of Justice, the Department of State, the Department of Homeland Security, and others. The chair of the committee is the Department of Treasury, so they host the meetings. Their job is to work with the rest of the committee to come to consensus on how to address national security concerns arising from foreign investment into U.S. businesses.
So when they make a decision, it's sort of an interagency decision?
That's right. No single agency acts on its own. The various members of the committee discuss potential outcomes and work together to come to the best possible resolution for a given transaction. The idea is rather than have a single agency or a single individual making these important decisions, the government puts different people in the room from different backgrounds, with different institutional interests, with different types of expertise, so that the committee is able to get a broad view from throughout the government as to how to address concerns.
Now, in March, President Biden publicly said he opposed the sale of U.S. Steel to a foreign company before a final CFIUS decision. Is that unusual?
That's very unusual. To my knowledge, President Biden's statement was made even before a filing had been made with CFIUS. And that's not how the process ordinarily works. Ordinarily, a filing gets made to the committee by the parties. They usually do that together, and CFIUS evaluates the transaction using what it calls a risk-based analysis. And that risk-based analysis looks at the threat posed by the foreign investor, the vulnerability of the U.S. business, and the consequences if a threat actor were to take advantage of a vulnerable U.S. business. And so looking at the threat, vulnerability, and consequences altogether, CFIUS comes up with its overall risk assessment and bases its recommendation to the president on that risk assessment. So back in March, to my knowledge, CFIUS would not have completed a risk analysis. And so the president really wouldn't have had the benefit of that insight from CFIUS in making his pronouncement. There had been no risk analysis. And to me, frankly, that creates potential litigation risk, because parties to the CFIUS process are entitled to due process. And it's hard to see where there would be adequate due process, which is the notice and opportunity to be heard, meaningfully heard on an issue, how they could have had due process if the president had already made a decision before the committee had done its work and done its risk-based analysis.
So now, as first reported by Reuters, CFIUS sent a letter to the companies in late August, warning that the transaction raises national security concerns that can't be mitigated by asset sales or other measures. What can the companies do to change CFIUS's mind or allay their concerns?
So it sounds like what the companies got is what CFIUS colloquially calls a Rawls letter or a due process letter. This has become a pretty routine part of the CFIUS process over the last decade or so. And really that letter, the rationale for CFIUS issuing a letter of that type, stems from litigation involving a company called Rawls that was building a wind farm in Oregon. And CFIUS was concerned that the wind farm could be used to house listening devices that would spy on a naval training base near the wind farm. And so CFIUS moved to block that transaction. The parties to that transaction sued and said that CFIUS's decision was not based on due process and actually invited the court to review the president's determination. What the court did there is it reaffirmed Congress's mandate in the CFIUS statute that courts should not stand in the shoes of the president and do their own national security assessment. And so the court didn't say that the president got the national security decision wrong. Instead, what it did is it said, hey, CFIUS, you need to go back and check and make sure that you gave the parties adequate due process. You gave them all the information about what your concerns are and gave them an opportunity to be heard on those concerns and to see if there could be some package of mitigation measures that would allay the national security concern short of a block. So that's what seems to be happening here, is CFIUS has now communicated specifically what its national security concerns are. And, I would assume what's happening now is the companies are, now that they understand what the concerns are, trying to convince the government that those concerns can be addressed in some way short of the president blocking the transaction. And that can involve, providing written responses that can include providing the opportunity for face-to-face meetings with senior executives and the like. And it's an opportunity now for the companies to try to convince CFIUS that there's a way to address the concerns.
Nippon Steel sent a senior executive to Washington today to meet with senior U.S. officials to boost its case for the takeover of U.S. Steel, according to Bloomberg sources. Would you call that a last-ditch effort to save the deal or just part of the process?
I mean, CFIUS has already said they have concerns. They don't think they can mitigate it. And so, normally in the process, that doesn't necessarily mean the decision's done, but it's kind of hard to get them to change their mind if they've gotten this far. So, maybe you could call it a last-ditch effort, but it is part of the process, right, where CFIUS gives a written description of the concerns and then the parties have discussions to try to address it.
Talking about due process, a letter from CFIUS apparently arrived on August 31st. The companies were only given until September 4th to respond. And also, the companies wrote to the panel asking to withdraw their submission, and CFIUS ignored that. Are those indications that might go toward a lack of due process?
They could. CFIUS is usually pretty liberal about granting companies an opportunity to withdraw a filing and to refile it, to stretch the clock and continue discussions on whether a package of mitigation measures can be constructed that would be adequate and appropriate to address the national security concerns. So it is abnormal, in my view, for CFIUS to not allow the parties to withdraw. And that's especially true in a transaction like this where the deal hasn't been completed. If we were in a situation where CFIUS was reviewing a transaction that had already occurred, then the national security harm would be accruing every day. And CFIUS may choose to act quickly in that case to stop the national security harm from occurring. But here the transaction is not done. And so it's odd to me that CFIUS wouldn't give the parties an opportunity to take the time to put together some meaningful proposals on how to address the government's risk concerns.
I'm not sure I really understand what the national security concerns are, because U.S. Steel has warned that if the deal doesn't go through, it could put thousands of jobs at risk and might force the company to relocate from Pittsburgh.
Well, first of all, I don't have the benefit of seeing the record, that's been assembled by CFIUS. And frankly, we never will have the benefit of seeing the full record. That's in part because CFIUS's risk analysis, the threats, the vulnerabilities, and the consequences posed by the transaction includes inputs from the intelligence community. And that goes towards the threat piece of that analysis, that threat variable. And the way the intelligence community defines threat is the capability and intent of a foreign acquirer to harm U.S. national security interests through a proposed transaction. And so what the intelligence community does, the National Intelligence Council, coordinates the entire community. That includes the FBI, the CIA, the NSA, the military intelligence agencies, the Department of Energy's intelligence agency, and others. It coordinates all those intelligence agencies, collects information from those various agencies, which includes very sensitive classified information that would just not be in the public regarding the foreign acquirer and potentially the transaction itself, to the extent there was collection involving the transaction. And so that all that information is put together by the National Intelligence Council in a document called the National Security Threat Assessment. CFIUS calls it a NISTA for short. So that NISTA, a highly classified document, is an important part of the record that the government is looking at, and that would be referred to the president as part of a risk-based analysis. So there may be something, if we want to give CFIUS the benefit of the doubt here, there may be something in that NISTA that indicates a threat that we just don't know about it. I'm hard-pressed to think of what that could be without the benefit of having seen that type of document and that type of reporting. But to me, that could be the type of thing that the government could be relying on in determining that there is a national security risk here.
Coming up next on the Bloomberg Law Show, I'll continue this conversation with Rick Sofield. If the companies decide to sue CFIUS, does that open the committee up to problems? I'm June Grasso, and you're listening to Bloomberg. Nippon Steel sent a senior executive to Washington today to boost its case for the $14.1 billion takeover of U.S. Steel, according to Bloomberg sources. The Japanese steelmaker's bid to acquire its American counterpart is at risk of collapsing, with President Joe Biden set to block the merger deal as soon as recommendations from the Committee on Foreign Investment in the United States land on his desk. Despite that, Japan's top government spokesman and ruling party leadership contender Yoshimasa Hayashi expressed hope that the deal could go through in an interview with Bloomberg last week.
It's still going on, and we don't know the result yet. So we really hope that even in this political year, both sides would agree with the mutual benefit and more free flow of the investment to each other.
U.S. Steel has vowed to pursue all possible options under the law to ensure that the sale is completed. I've been talking to Rick Sofield, a partner at Debevoise Plimpton, who was formerly the Justice Department's CFIUS representative and participated in the review of more than 1,000 transactions. If the companies decide to challenge this in court, what are the risks to CFIUS in a proceeding like that? Would the elimination of the Chevron doctrine play a part?
So this is a really interesting question. Firstly, the Rawls case, it kind of gave a guideline of how the court might think about due process. And so I think certainly here there could be some due process arguments, particularly in light of the fact that, the president put his thumb on the scale back in March before any record had been put together. And so I think that can really call into question whether or not there has been due process here. The decision might have been made before the transaction was even filed with the CFIUS committee. And so I think that can put the government in a very difficult position if due process arguments are raised in the courts. Now, on the issue of what effect the overturning of Chevron deference might have, I do think this is a tougher argument, but maybe not an impossible one in today's environment. And that is, Congress has said that the courts should not put themselves in the president's shoes and assess national security risk on their own, that the courts should defer to the president's authority in this space. And deference to the executive branch, to the president on national security matters, it's a longstanding precedent. It's a longstanding deference. And it's for good reason, right? The president has the benefit of inputs from the intelligence community that the courts just don't have. And so to kind of attack that longstanding deference, I think that's an uphill battle. That said, though, we have this trend that we're seeing in the courts away from giving deference. And so, that could impact the court's thinking here, particularly if we're in a circumstance where there's a really weak administrative record, where there are significant due process concerns. That could invite the court to go further than just pointing to due process fouls and to potentially somehow put guardrails around or curb the president's supreme authority to make national security determinations through the CFIUS process.
That would be a first then, right?
Absolutely would be a first. But, there's a saying in legal circles that you've probably heard, which is bad facts make bad law. Mm-hmm. If you've got bad facts, you've got a bad written record. You've got a record of sort of the decision maker making a decision months before the matter has even been put before him. And then, the supporting documentation is not convincing, that the parties are not given an adequate time to prepare responses to the government's written concerns. And you have all these factors pointing to perhaps a precipitous decision by the government. You could be inviting the courts to take aggressive action. And so, yes, I think it would be novel for sure. And I think it would be a hard argument to make and win to challenge the president's national security determination. But if you give the court a bad enough record, they just might do it.
There's something else I'm curious about. So Nippon Steel and U.S. Steel have engaged in a nearly year-long attempt to win the support of the United Steelworkers. And today on a website, bestdealforamericansteel.com, the two companies made their correspondence with the steelworkers public in an effort to show how union leaders snubbed their efforts to negotiate an agreement. And the documents show, for example, that there were promises of no layoffs or plant idling or permanent closures, et cetera, et cetera. But the union remained firmly against it. And I'm wondering if it's unusual for companies to be dealing directly with the union like this before the deal's even finalized? Or is that par for the course?
So, what is par for the course is for, the parties to a transaction to work with other interested parties to identify potential national security concerns and to craft mitigation measures designed to address them. The idea here would be that the parties want to get out in front of these concerns. And when they file with the government and when they are engaged in this back and forth with the government where we are now, where the government has identified national security concerns, the company doesn't necessarily want to be reactive. They want to have gotten their ducks in a row to be able to make the arguments to the government that their national security concerns can be addressed. So, I can't say that I've seen it where there's been sort of discussions with a union and acquiescence from a union in order to get government approval. But to have other stakeholders who are involved and on board with a package of mitigation measures, that's consistent, right? That's with normal practice. Companies do this all the time, and it's part of just good management of the CFIUS process to have your ducks in a row and to be prepared to address any concerns that the government might raise.
Let's say the companies do challenge it in court How long would it take, do you think, to play out? Months? Longer than months?
It can take months or years. There's no certainty, when you get to this litigation stage. And so it's really hard to say how long a litigation process would take to play out.
And it's looking like litigation is the only possible answer for Nippon and U.S. Steel, especially since former President Donald Trump has also expressed opposition to the deal. So no matter who wins the election, the next president will oppose the deal. Thanks so much for joining me, Rick. That's Rick Sofield, a partner at Debevoise Plimpton. Coming up next on the Bloomberg Law Show, Sam Bankman-Fried's former girlfriend and the government's star witness against him is asking a judge not to give her any jail time when she's sentenced this month. I'm June Grasso, and you're listening to Bloomberg. Caroline Ellison was the star witness in the government's fraud case against her former boyfriend, the one-time crypto wonder boy, Sam Bankman-Fried. And now she wants a get-out-of-jail-free card. The former Alameda Research Chief Executive Officer is pointing to her, quote, extraordinarily impactful cooperation in one of the country's biggest financial crime investigations to convince a judge to spare her from spending even a single day in prison. In a sentencing memo late Tuesday, Ellison's lawyers portrayed her as a talented woman caught under SBF's spell as his on-again, off-again girlfriend who wound up helping him commit crimes. Quote, she regrets her role deeply and will carry shame and remorse to her grave. Joining me is Ava Benny-Morrison, who covered the trial and has looked at this 150-page sentencing memo. Ellison is trying to get away with no jail time at all. Tell us what argument she's using.
Caroline Ellison filed a sentencing memo in court, essentially putting her case forward for the judge to spare her from serving any prison time. She says that she was in a pretty unique and complicated situation with FTX founder Sam Bankman-Fried. They were in an on-again, off-again relationship, and he was manipulative, very hot and cold with her, and she felt like she was forced into a position to help him with his crimes, and she couldn't leave. She's asked the judge to take that into consideration, but most importantly, take into consideration the fact that she was the star witness for the government in its case against Sam Bankman-Fried. As soon as FTX collapsed in late 2022, she flew back to the US. She met with federal prosecutors and regulators, told them everything that they wanted to know, even pointing them crimes that were committed by Sam Bankman-Fried that they didn't know about. She's put all of these arguments forward in a bid to try and convince the judge to just sentence her to supervised release.
In the memo, a lot of time was spent on her on-again, off-again relationship with Sam Bankman-Fried. Did that somehow give her a pass?
It did form quite a central part of the sentencing memo, which was more than 150 pages. And her lawyers went into pretty intimate details about what that relationship was like, more so what she felt about Sam and how he was treating her. She felt very isolated. She felt manipulated by him. He was trying to balance a romantic relationship and a professional relationship with the man who was her boss. Her lawyer said in this document that when she tried to leave Alameda, he would shower her with professional compliments, tell her that he loved her and that she was a key part of that operation, and it couldn't possibly go on without her. So she sort of painted this picture of being stuck, but at the same time really losing her moral compass and helping Sam Bankman-Fried carry out this multi-billion-dollar fraud at SBF.
Talking about details in the memo, did they actually talk about her wanting to be invited to the Met Gala in 2022?
They did, actually. They gave some examples of the dynamic between her and Sam Bankman-Fried. One example she gave was when Sam was invited to the Met Gala in 2022, and Caroline was really excited about this, and she asked if she could go with him, and he said no, and completely rebuffed her and said that he didn't want to be seen out in public with her. That's the version of events put forward by her lawyers. They also said that he never invited her to any of the kind of flashy crypto industry conferences that he would go to, and really went to great lengths to keep their relationship a secret.
It sounds more like a novel to me than a sentencing memo. They also tried to distance her from this lavish lifestyle, portrayed her as someone who shopped at the Gap and gave to charity and all this stuff. I mean, how did they try to portray her? She did make a lot of money, didn't she?
Well, she was paid a pretty decent salary, and she said that she received bonuses, generous bonuses, in line with a lot of the other executives at FTX and Alameda Research. But you're right, her lawyers really tried to portray her as someone who was humble, who wasn't interested in the finer things in life just because she was a wealthy human being. They sprinkled little anecdotes throughout the sentencing memo from friends and family and former colleagues saying, Caroline loved to shop at the Gap. Her mum even mentioned that she had to buy her shoes because she was so disinterested in buying anything for herself when people couldn't even afford to eat around the world. So they really tried to distance her from some of the more extravagant and lavish elements that are associated with the crypto industry.
They said that she's continued to suffer even after the trial. How so?
Caroline's lawyers have said that she was subject to intense public scrutiny, that trolls online speculated about her whereabouts when she went outside. She had to disguise herself, that she was pursued really heavily by the media, and they say that she has suffered more than other people that were employed at SBF and Alameda, and this should be taken into account.
She's been rendered effectively unemployable in the near term, according to the memo, and they also mentioned that she has a new boyfriend now.
She does. She has a new partner, and her lawyers had asked the judge for permission to redact some of the more personal details in this sentencing memo relating to where she's living now and her partner, to kind of protect her from that ongoing public attention. But yes, she is working, but as a volunteer, and her lawyers said that she's also chipping away on a couple of writing projects, fiction, and even a math textbook.
I was surprised. The probation department recommended she serve 3 years of supervised release, but no prison time.
Yes, the probation department said that she should be spared any prison time. And look, it's not that unusual for cooperating witnesses to be spared from prison or serve a very, very short sentence. In a case like this, Caroline Ellison, along with 2 other former FTX executives, were really key to the government's case. They all turned up and testified against Sam Bankman-Fried at his trial in late 2023, which eventually led to his conviction and his prison term of 25 years. So it'll be interesting to see what Judge Kaplan does here and how he weighs up the value of Caroline's cooperation, and whether he finds that she should, in fact, spend at least a short period of time behind bars.
And federal prosecutors haven't said yet what they'll ask for?
No, we expect to hear from them in the next week or so, and they will put up their own recommendation for what they think would be an adequate punishment for Caroline. They could side with the probation department and say, yes, we don't think that she should do any time because she was so valuable for us. Or they could go outside of that and recommend some prison time. But ultimately, it comes down to the judge, and he will make a determination as to what he thinks Caroline should cop.
And the former FTX Digital Markets co-chief, who pled guilty but didn't cooperate, he was sentenced to 7.5 years in prison. I don't know if we can use that as an indication because he didn't cooperate, but 7.5 years is pretty substantial.
Yes, absolutely. And that was actually above the recommendation that the prosecutors had put forward and that the probation department had outlined as well. But Ryan Salem was a little bit of an outlier because he hadn't signed on to be a cooperating witness and testify against Sam Bankman-Fried at trial. So he couldn't fall back on that and make that same argument that Caroline is making, in that he helped the government put their case together and he was a key part of it. So I think that's part of the reason why he got such a big sentence.
And that was Judge Kaplan who sentenced him as well, the same judge that's going to sentence Ellison.
That's right.
We will find out what he decides at her sentencing on September 24th. I know you'll be there, Ava. Thanks so much. That's Bloomberg legal reporter Ava Benny-Morrison. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.